There we go.
Okay, we've got it. So we'll turn the time over to Heather White. Thanks, Heather.
Great. Thank you so much for having me here today. It's my pleasure to be with you all. I was just looking at a list of people, and I commented on what an impressive group of people we have throughout the state. As you are aware, these officer-involved shootings are really big news. They're big in the public, they're in the media, and they're big topics in the legal field now. And so what we want to do is to help provide you with information prospectively, so that it's not often now a matter of if you have an officer-involved shooting, but when you have one, you're prepared and ready to go. And let me just start out by saying that if you have any questions that you're not comfortable asking, or we don't get to them today, please call me or email me, whatever you would like. My cell phone number is 801-201-7220. And my email is hsw@scmlaw.com. And you are free to use either of those anytime you need, middle of the night if you have something, because that's how these issues work. As Jason mentioned, there's not a day that goes by that it seems that we don't have something in the news about officer-involved shootings. I was reading the Tribune this morning before coming down here, and there's one, of course, in the news this morning, whether it's a shooting or the aftermath of how to deal with it. So, the climate in the nation is a very difficult one for police officers these days. And as we see the difficulty that we have in recruiting officers, we see how police officers really are highly scrutinized and under attack by the public who do not understand fully what the officers have to go through in making the decision to pull the trigger or not. People walk around with these, we call them cell phones, but really, as I watch my two teenage sons, they're not cell phones. I can't get them to answer their phones. They use them mostly for the internet. And so they walk around with these little computers in their pockets, and they are able to obtain immediate answers to any of the questions that they have. And so we have a culture now that when something happens, people want it immediately. And we've seen that with a recent shooting in Salt Lake City, where there's body camera footage and people want that released before the investigation is complete. And sometimes that's appropriate and sometimes it's not. And we need to help be prepared to deal with those issues, because these people want immediate answers and they want what they feel is accountability and transparency. I think what they don't understand is that we have been, for the most part, accountable and transparent. They just don't understand that. And so we need to do a good job of educating them and not being defensive, but help educating them through the process. So the impact that officer-involved shootings have is very far-reaching, not just on the officers, but on their agencies, on the insuring entities, on the municipal employers, the city and county officials, and it also affects various aspects of the officers in their lives, starting with the criminal. That's where we begin, is at the criminal stage. And it's really important to note that while there are these various impacts that it has, what I'm saying today is I'm not giving you the best practices as to how to run the criminal investigation or the employment investigation. We're focused on managing risk. And the importance of this is that we have criminal, employment implications, and those are usually dealt with before we get to the civil implications. But the one that has probably the broadest overall impact is the civil. There are several reasons for that, because even if an officer is absolved in the criminal employment settings, a civil action has a lower standard. And if a constitutional violation is found, it can have implications not only for that officer, but for the officer's employing entity in future cases. Also, they are by far the most expensive and public parts of the officer-involved shooting process and what occurs after that. So what I'm going to be talking today about is how to manage risk in that. And some of the things that I'm going to say are going to probably not harmonize with how criminal investigations have typically been done, or employment, or how you might want to see that. But these are the best practices from the civil, and we have this tension between these different types of impacts and different venues of what happens when there's a shooting that now really has to be considered. We didn't before have to often separate out the criminal, employment, and civil, but we're having to do that more and more lately as we've seen the officers being charged criminally, or having maybe coded criminally but having employment implications. And so we're going to have to start weighing certain things that we do more than we did in the past, and we're going to have to be making decisions. So the purpose of our discussion today is to address some of the changes in how OIS investigations are handled from the civil standpoint, recognizing this tug and pull between criminal, employment, and civil, and to learn both from cases that we have experienced here in Utah and as members of the trust and around the country about what we do when it happens, and how things are conducted. The legislature made things easier for us from the investigation standpoint last year by requiring that an outside agency conduct all officer-involved shootings from the criminal standpoint once the shooting occurs. And I have been preaching this for years. We have had this protocol in several of our members' jurisdictions, but in many that has not been the case. And it has led to some issues, not necessarily with the agencies investigating their own, but really from arguments that opposing counsel are able to make. And so really this is an opportunity for improvement to eliminate, it's a risk management tool really, to help eliminate arguments that, that our opponents make, and also to take away any bias, pro or con, because that can happen within a police agency that an investigating agency might have. So it's always important to have an outside agency investigate an officer-involved shooting. And as we've discussed, it's now required by the statute. One of the other things that's really great is that in having what is typically referred to as a protocol team, we have people who are experienced and trained first and experienced in doing these types of shootings. It's really important that they have an understanding of what is involved, because we learn so many different things, for example, through the Force Science Institute, which I went and became certified a couple of years ago, about perception and reaction time. And it helps us to understand the officer's perspective, because that is the standard, after all, is did the officer act reasonably? And so by having people who are trained and have experience in doing these very types of investigations, it really helps manage the risk for our officers and our employing entities. One of the things that I have been preaching recently that has become quite, I think, difficult and maybe controversial is, do we allow the officers to give an interview? Typically, that has just been done as a matter of course. An officer is involved in a shooting, the officer is interviewed that night. Things need to change as a result of the changing landscape. I will tell you that there are many interviews that can be helpful to officers, and there are times when it may be appropriate. But I have never, I caution against having the officers do it for several reasons from a civil standpoint. Again, please remember that it is taken in this context. First of all, they have a Fifth Amendment right not to testify, and anything they say in their interview can not only be used against them criminally, and has been in the recent past, but is then used in a civil action. And the problem with this is that we have, well, let me back up to some of the problems. We have essentially, from the civil standpoint, it's the last thing that we get to. We have the criminal investigation and then often the employment. And we already have the statement that an officer is given, and it can be used in the civil case against the officer and the officer's employing entity. And this is really essentially having an officer go in and give a statement without a complaint on file, so we don't know what the allegations are. The officer doesn't have a civil attorney that is keyed into what the issues are in the civil case, and basically giving a sworn statement like a deposition without the opportunity to have the officer's counsel ask any questions, because that's not allowed in the criminal investigation to clear things up like I can in a deposition. So it's like going in, giving this deposition without having a complaint on file, without having counsel, without knowing what the claims are, and without having any preparation time. And that can result in some serious consequences in the civil arena. So that's why I'm counseling people, and we'll talk about it more later, that I'm not saying don't do it under any circumstances, but it's something we have to weigh now. It's something we have to think about. It's not just a given. Another issue that we really have to look at is when and how we do IAs and debriefs on a situation. I had a recent shooting that was where I worked very hand in glove with the employing entity on this type of an issue, and was involved in the process of drafts and the scope of the IA. It was so important because the IA becomes discoverable in a civil action. And again, we're talking huge amounts of money because of attorney's fees, especially when we have a shooting and a death. And so really we need to ensure that we limit the scope of those IAs to a policy violation, that we not have any comment or editorials on the officer's conduct. Basically want to limit it, and we'll talk about that a little bit later on how we limit the scope of that to help manage the risk. The other thing we want to ensure is that we have the evidence we need in place to defend against these civil claims that will help us in the criminal arena, but not always do the criminal investigations think about things that we really need and can use in the civil context. We now have the issue of body cameras and other recordings, which is helpful really to the officers. And when I went and was Force Science certified, the experts at Force Science said, even if there's something troubling on a body camera or a recording, I'd rather have one any day than not having it. We can deal with those issues. And so these body cameras, video recordings, dash cameras, a dash camera is really helping in a case that I'm defending right now, where a gentleman says that an officer is claiming an officer was overly aggressive, but you can see the officer doing the very thing on camera and acting in a very calm manner. So they can be extremely helpful. And let's not forget, even if we don't have any of those video recordings, how helpful even audio recordings can be. We also need to take into account human factors, and that is an officer's perception, and this is where the trained investigators are so important, is that an officer's perception is going to be different sometimes than forensic evidence. And that does not mean that the officer is lying or is stretching the truth in any way. Human ability to perceive and react can be very different from what actually happens. And so to understand those distinctions is crucial in this context. And not to underestimate the power of the media. The media is behind the huge explosion of interest in these officer-involved shootings we have seen in the last couple of years. They are the driving force. And so in the past, we've been very reticent to address the media, but the time for saying no comment is over. We have to deal with the media. We have to address them, but we have to do so in a way that will not harm not only what the issues are in the case, but from that very outset of when a shooting occurs, we are starting to create with the media and the public the character of the officer and the entity involved, and to shape that. And those are going to become our jurors. And so the media is now part of what we do in managing the risk of the case and assessing where we're going with it. So it's important also from the public trust standpoint. As in law enforcement, the very most important thing that we have is public trust. And if we're not willing to share, and it doesn't mean we share everything, but sometimes just explaining to the media that we are working on these certain issues, we build public trust so that not just in the case in front of us, in the shooting in front of us, we have more public trust, but we have built that in the past so that, there's a foundation for them to believe and rely on what we're saying. So we need to adapt. So we have all these changes that have happened in the last couple of years, and now we need to adapt to those. And we do that through training, training our officers, training people here, training the public and the media on what we do and what to expect. And then the training has to be, we can train all we want, but it has to be carried through to actually implement how we do those things and where we go. So let's start at the very beginning of when an officer-involved shooting occurs. The people there first are going to be the officers, and it's important that they're trained and understand what to do. And it's so important that they have this training because it becomes muscle memory. When you're involved in something as traumatic as a shooting, it has a huge emotional component for the officers. And so that's where the training comes in and kicks in, and is so important that they have they've been trained on it so long that it just becomes a matter of it kicks in, just like they do in when do you use force and their defensive tactics. The first thing that they need to be trained on is, of course, to ensure the safety of themselves and the public. And then once that has been accomplished, to notify a supervisor. And the reason that is so important is because the officer has all of the adrenaline and the adrenaline dump that comes with being in the shooting, and there needs to be someone who has the ability to step back and is not dealing with the emotion, the physical and emotional impact of being involved in the shooting. And that applies as well to officers who are at the scene but don't necessarily fire their weapons. They have that emotional component going too. So notifying a supervisor to ensure that that supervisor gets the process started and on its way properly is critical. It's also important for the officers to secure the scene and maintain the perimeter until the agency who's going to do the ultimate investigation arrives. And that includes witnesses. It's so critical to know what those witnesses are going to say right after they have witnessed it, when their memories are fresh and unadulterated by what they see on the news, or have talked to people, or had time to think about things and or think about, you know, possibly claims, those kinds of things. So identifying those witnesses and keeping them there if possible. Now, that does not mean that we can hold witnesses there. And we've had claims where we've had righteous shootings, but we've had witnesses held against their will. That cannot be done. The fact that they have witnessed the shooting does not require that the Fourth Amendment applies. It's a consensual stop. You can require they provide their information, their identification, and their contact information, but they are free to leave. And it's important that we understand that. And maybe now, you know, maybe we can send someone over to their house after, or offer, if they're not willing to stay there, you know, offer another time. And again, it is critical to get their stories as soon as we can, and most witnesses are willing to do that. But when we come across someone who is not, or who, you know, says, and it can be family members. We've had instances where family members have been there at a shooting, and they want to leave and go be with their loved one, or, you know, if they think they can do that. It's crucial that we allow them to go. We cannot hold them against their will, and it can lead to a civil rights violation, just as a shooting can, and in many instances of civil rights violations, the damage component that is the most expensive are the attorney's fees. And so whether it's a shooting or an unlawful detention, those attorney's fees can be the same. So it's important to remember that. And then we want to make sure that the officer calls the officer's attorney. There is no situation where we want an officer not to have someone who is looking out solely at for the officer's interest in that critical moment. So we want to make sure that the officers have access to phone numbers for their criminal attorneys that they call right away, that they're ready at that moment. They know who it is that they are going to call. Then the next people that generally respond next are the initial responders, and those typically are officers in the jurisdiction because they're closest by. What we want to ensure that they do is not begin the investigation. Again, it's the protocol team that's going to be conducting the investigation, and they need to make sure, if the supervisor hasn't already invoked the protocol and notified the protocol team, that the initial responders do so. And that's to protect against those very problems that can arise from the perception of investigating your own. And now it goes against state law. So there's an added importance to that. The initial responders should also remove the involved officers from the scene, so that there is no ability for people to claim that the officers did something inappropriate, took evidence, moved evidence, tampered with any witnesses. And again, if possible, get those written witness statements right there. I can tell you I've had 2 cases where written witness statements at the scene, done, one on the top of a truck, the other probably on the hood of a car, have directly contradicted statements made in depositions, in court, and to the public, and to the media after they have occurred. And those written witness statements in those witnesses' own handwritings have really saved the day. So if possible, get those written witness statements right away and do an interview following that if possible. It's just very powerful to have that time on there. And it's important for the officers to remember, write that time on there. I've seen witness statements that are helpful and it's great, but we don't know exactly what time it is or who did it. It's important for the officer gathering that witness statement to legibly write the officer's name so that we can then call that officer as a witness. to verify that the witness did indeed write that statement. So, so number one, we want to get those witness statements in their handwriting. Number two, we want a time so that we'll know when that was given, and we need an officer to lay the foundation for that in case it becomes an issue. And then we want the initial responders to ensure that the officer has called the officer's attorney, but then also to notify civil counsel, whether that is someone within the municipal or county agency, the county attorney or the city attorney, or if it's outside counsel like me. And I will tell you that things work best when you involve civil counsel up front, even outside civil counsel. The cases that we have had where I have had the opportunity to work from the beginning and help direct what I need to help defend against the civil claims have been the most successful ones that we have had. The next people that will be responding will be the investigating agency. And they will come and assume incident command. And it's important that our officers be trained to let go. And that's really hard for officers to do because that's why they're in this position. They want to help. They run in when others run out. And it's important for them to know that this isn't their investigation anymore and it's nothing personal. You know, they need to let go and trust that protocol team who has trained, who has experience in dealing with the shootings. Make sure to let them do their job. The investigating agency will then make the appropriate assignments and ensure that the proper things get done. What we want to do then at the next point is look at the scope of an investigation. And as I explained to you before, a criminal investigation will affect the police officer and the officer's employer long beyond the shooting. It not only will affect them, but law enforcement as a whole. As we see shootings in different venues and jurisdictions, we are all in this together. And so it affects, again, that public perception and affects law enforcement as a whole. And it's really important to remember what we do affects our other brothers and sisters in blue out there. And we need to be most professional, transparent, and honest in all that we do. We want the most accurate investigation possible. Sometimes that takes time, and sometimes that's not what the public wants. And as I explained earlier, it doesn't mean that we release information prematurely to the public. We just need to sometimes, and sometimes we can. We need to assess, does it really harm the investigation if we're able to put a body camera video out there, or is it going to affect witness statements? It can go both ways, and that's where we have to give it the discretion. But that's where it's important that we work together with the investigating agency so that then we can update the media as well so that we build that trust and provide them with an explanation. They don't care what it is we say. They just need our side of the story. And the public needs our side of the story so that they understand we're not just sitting around trying to hide things from them. And then it's critical that in conducting the investigation, if your officer is part of the protocol team, that they look at the facts and circumstances through the officer's eyes and not through again, the Graham versus Connor standard, through the 20/20 vision of hindsight. We do that sometimes and can be judgmental. And it's important to remember in that investigation that we look at it through what the officer was thinking and feeling. Again, we don't want that 20/20 hindsight. And this is where I've seen entities get into trouble, is there can be difficult relationships within departments and even outside of departments where someone doing an investigation is not particularly fond of the person, I mean, maybe involved in the shooting. Just because the person involved in the shooting is not well liked or the darling of the department or anything like that doesn't mean that the shooting was inappropriate. And we have had instances where there has been editorial comments made that have shaped, or not even comments made, but viewpoints that have really harmed the officer that come across and bias the investigation. We need to look at those very factually and not be advocates. And that goes for being a positive advocate for the officer either. If there are some squirrely things that are present, they need to be noted and dealt with. It does law enforcement no good to protect against things that are inappropriate. And we have a duty and a responsibility, not just to our departments, but to the public, to ensure that trust and that transparency is indeed well placed. And so, again, that doesn't mean that we go through and provide the editorial comments. We do just the facts, the Joe Friday, the factual investigation. Let's turn now to talking about civilian witnesses. We talked a little bit about the detention and how the Fourth Amendment applies. It is now clearly established in the 10th Circuit that the reasonableness, the Fourth Amendment reasonableness requirement applies to the detention of witnesses. And to hold someone against their will on a consensual encounter is improper. The test is the reasonableness test that courts will look at is that balancing test, that the tug and pull between the seizure and then the interference with individual liberty. So what are some of the possible interests of holding someone? The first is obtaining information, and we all know under those consensual stops that we're authorized to require someone to give that identifying information. So we want to obtain that. The names and addresses of the witnesses. Here, the court addressed whether then getting statements, and this is a case that I was involved in. We ended up trying it and prevailed, but it went to the 10th Circuit, and a summary judgment ruling was reversed and sent back, and that's why we ended up having to try the case that a 90-minute detention was not reasonable to try to require these statements where a family wanted to leave. So it's important and crucial that we understand that. Now, exigencies, just as exigent circumstances, can make a longer detention reasonable, such as securing the crime scene. You know, and the court made a particular point of that detaining witnesses is different from excluding them from the crime scene. The scope of duration is something that they will be looking at. So when you're looking at the exigency, I mean, is there something that puts the public at risk, those kinds of things? Something, it can't just be, we need this witness for our investigation. What they have to say is important. That is not enough. And I would encourage you to take a look at the Walker versus City of Orem case, and let me know if you have any questions about it. But other exigencies such as, you know, the safety to the public or to other officers, you know, if a witness knows the identity of someone who has run away and they have a gun, you know, and possibly can be a threat to others, that may be a different story. And I'm sorry that it's one of those things that there is no pat answer. Again, it's that reasonableness determination that our officers make day in and day out. One thing that I have noticed too that has been lacking in investigations that I would encourage you all to consider and include and talk to agencies is to ensure we get photographs and video of evidence. But what I've been missing in many instances are photographs and videos from the officer's perspective. It's very different to have a photograph just of a general area than it is of where the officer's standing and looking to where the suspect was shot. There can be obstructions that are there. There can be lighting issues, all sorts of things. And we want to capture those photographs and videos at the same time and the same of day to try to recapture that lighting and the same time of year. I had a case where a man, it was a big SWAT operation, and a witness came from nowhere that we weren't aware of who claimed that the gentleman who had been shot had his hands in the air with not a gun, and he had pointed the gun at a SWAT officer and been shot, and that's what resulted in his fatality. This man comes in from nowhere and says that he was in a building overlooking the scene and that the suspect who was shot had his arms in the air and didn't have a gun in his hand. And that creates a fact issue right there for a summary judgment motion. What we did is a year later to the day, we went to the scene and had people take photographs of the window where he claimed he was standing overlooking that. And you could not see the area where the suspect was when he was shot. And we got him to draw that on a picture during his deposition. And so when it came later for the summary judgment motion, which we won, and the judge said there is no genuine issue of fact because this witness can't be believed, the tree was blocked. There was a tree, and it was and a fence, and it was blocking his perspective. So it's really crucial that we get those photographs and videos then from the officer's perspective and any other witnesses there that we're aware of from their perspective. What they do, again, is it shows what the person who is testifying can and cannot see. It helps us to determine the distance, any obstructions, lighting, as we've talked about. And that's important for just not only the officers, but for the suspect as well, because it's important to know what the suspect may be able to hear or not hear. It's also, although it's not determinative, really what is determined is the officer, but it can help us in making those arguments. And it's also, if we've identified a crucial witness, to get those from that witness's perspective as well. All right, so we moved on to the involved officers. We've gone from the responders, the witnesses, and now we are moving on to the involved officers. You know, sometimes there have been statements that have been made, including a walkthrough. The statements at the scene. There's even some issue as to public safety statements right now. I don't have an issue with that, and I think those are important because they address, you know, whether there are other suspects at large, whether they are a danger to the community. So I don't have an issue with that from the civil standpoint, and I think they're very important. I think it looks bad, too, if an officer is not willing to give a public safety statement. But those are basically limited to how many people, you know, what did they have? I wouldn't ask the officers how many shots you fired, because I can't tell you how many times an officer thought the officer fired 2 shots and it was 8. And then again, there we are. We have an officer who says something that's different from what the forensic evidence provides. And we have those experts who can explain those differences, but it's always better not to have to deal with those. And does it really matter? Does it really matter at that critical moment how many shots are fired? It really doesn't. That's part of the investigation. What matters for the public safety statement is are there people out there that are a danger to the public, or has the threat been eliminated? So I would adjust those public safety statements in your departments to really limit the scope of those. And, you know, that's something that we can take a look at. I'm happy to take a look at and let you know if I think it's more broad than it needs to be. Then there are the statements that we've talked about that they give the voluntarily. And again, the officer has the Fifth Amendment right. This is a criminal investigation, not to provide a statement. The first thing we need to take a look at is it really necessary? With all the witnesses that we have, does it matter? I mean, let's interview those witnesses first and see what they have to say. They may provide all of the information necessary, and we don't need to have the officer's statement, and then we don't send that officer in to a deposition, again, or a statement under oath without a complaint, without claims, without a lawyer able to protect the officer's rights and object and not instruct them not to answer. You know, so is it necessary? We've got body cameras now. We've got forensic evidence. So I would say it's one of the, you know, it's something, it's not just a given anymore. Is it necessary? Oh boy, we've gone through that. Is it helpful? That's the next assessment that needs to be made. Sometimes it's necessary to help provide context. But let's take a look at those other things first, those body cameras or other recordings from witnesses, the forensic evidence, the other witnesses, and then we can make that assessment is, does it fill in any gaps? I mean, is there things that don't make sense from what the body camera shows and the other witnesses are saying where we need the officer's statement? So does it provide that context? Does it fill in anything we're missing from the other evidence? And then we need to take a look at, do the benefits outweigh the negatives? You know, that's something I've discussed at length with criminal attorneys that I have a very good relationship with, that I've worked with at the get-go from these shootings, and they have the same feeling that we do. It's something that you can't, there's no pat answer to, and you really have to take a look at. Is it something that's going to help my officer get cleared of criminal charges? You know, is the county attorney teetering on whether to charge or not, and do I think this is going to make the difference? Is this officer just really impressive and articulates well, or is it an officer that struggles? So those are the things we need to start taking a look at. The next thing we need to remember to do is to examine all of the evidence from the officer's perspective, excuse me. And perception, again, as we've discussed, can be different from reality. We've got different senses that we rely on in assessing what the officer said happened. There's the officer's sight, what he or she sees, and that's broken down into their focus. And we know from force science that our attention is limited. As much as we like to say we can multitask, we can't really multitask. We can be doing two things at the same time, but our attention is limited to one thing at a time. We're only able to see about a quarter, or it takes about a quarter of a second for us to see, to perceive what is happening. And then it takes other time, and we'll talk about it a little later, what that means in terms of the timing of how to respond. The other thing that's important to remember is that our attention is selective. We not only can we only attend to one thing at one time, we can only concentrate on one thing at a time. We also can see things only between 1 and 3 degrees. We have that peripheral vision outside of those 3 degrees if we're lucky to be one of the people that has the 3 degrees. I'm not. And so, but it's not enough for us to be able to focus in on that. And so I guess that's something that we need to remember as we're moving into March Madness, that maybe we thought we saw travel at this other side of the court, but really our focus is limited to the guy we're watching, and that's usually the guy with the ball. So we might have to give the ref a little bit of credit. I hate to admit that. But back to the task at hand, it takes about 2/3 of a second for us to change what we're focused on at one point to another, and that increases the older we get. And you'll see that as you drive. I'm finding that as I drive, as I'm getting older, it takes me longer to be able to look at from one lane to the next, to be able to decide whether to change lanes, and I can't do that as quickly. The same thing applies to our officers. And so that's where we get this phenomenon where things can be happening in the background or the foreground or next in the officer's periphery, but they don't see it. And what people have seemed to think that means in the past is the officer's not being truthful or the officer's not paying attention, and that is indeed not the case. They are focused on that gun usually, and you will hear them talk about how they could see the barrel of the gun, and they really focused in on that. And we'll talk a little bit more about visual and auditory exclusion, and it results in this phenomenon of look but not see because they're so focused on that small area. Another term for that is cognitive blindness. And so that can result in what is forensically inaccurate perception. There's also this phenomenon that I learned about from forest science where our brain fills in the blanks, and that comes, and we fill in the blanks from what our experience has been, our experience and our training. And what happens is we don't see something, but we think we did because it's what has happened in the past or what we're trained to think has happened. And it's really a physiological phenomenon. So an officer can testify or say something in a statement that they saw this or heard this, and really there was no sound there. You know, it can be as simple as the number of shots to what the suspect was doing. And it's, again, not that the officer was lying, it's those perceptual issues, and it's why it's so important that we view these facts in light of what the officer was facing. The officer can have what we're all familiar with, the tunnel vision, and that's where it is. They zoom in on that focus on that one thing, and also pupillary dilation, where they don't have depth perception. And that was really important in a case that I handled, not in the too distant past, where you know, an officer thought he was in one place, and other people felt that the officer could have been in a safer area. I think most often that is going to be the case when we're dealing with cars, but it could happen in a variety of other circumstances, is that they don't know how far away the threat is actually from them. And while someone may take a look at the actual forensics and say 20 feet, you know, if someone with them is, say, 30 feet away from them, coming at them with a knife, they may perceive that to be 10 feet because they are so focused in on that knife that they lose that ability to determine how far away that person is. And so it can affect whether they fire or not. There's also an interesting phenomenon called looming. I thought this was really interesting, and that occurs when something is coming at the officer, a car, a person with a weapon, and the closer that threat comes, the bigger and faster it seems to be coming. So an officer can be testifying that a car, you know, was moving at them at, you know, 30 miles an hour when there are no skid marks or tire tracks or marks on the ground. I think if I remember correctly, you have to be going faster than 10 miles an hour to get skid marks. It can vary, but if there were no skid marks on the pavement, and so on a case that I had, and so the argument was the officer was lying about that. Well, again, that's not true. The officer felt that, I mean, I don't know how you guys have been. I've been in this situation having a car come at me with one of my kids one time at a park, and it seemed like it came awfully quick and fast, and probably faster than it did. And so that's going to affect how an officer responds. And it also affects the perception of, it doesn't affect the other witness's perception, but a witness at another angle is going to not have that looming phenomenon. And so they can come and say, oh no, the car was only going 5 miles an hour. It wasn't a threat. But again, they weren't the one who was in the path of that car, having the car come at them with no other option. And again, remember, it takes that time to see and respond. And the officer may feel that firing is their only option and not being able to get out of the way. Other physiological phenomenon that affects officers is the hearing, and we know that there's the auditory exclusion, muffled and distance, and again, that can affect how many shots are fired, as we mentioned briefly before. There's also time distortion, and all of us who have been in a close call in a traffic situation have experienced this. Things like things move in slow motion, or things can speed up, and things can seem like they move very, very quickly. So, you know, it's just because that's why it's so important for us not to pin the officer in on time, distance, location, because the officer's perception of all these things is likely distorted by the stressful situation that they're in. And by then pinning them into exact numbers and details is setting them up to fail. That's what we're doing when we ask them on the diagram to show us, draw a diagram and show us where you were standing. We are setting them up to fail. And so what we need to be able to do is have them give us the general area of where they were. Generally, you know, I don't know, we're going to have to change the way that we ask the questions and the questions that we ask so we don't create these issues where there aren't any. And that's why it's so important to have, again, these protocol teams who are trained in these very types of things. And I would recommend that any person involved on a protocol team go and get Force Science trained. It changes the way you think of and see things. And I've been doing this for 18 years. I've been doing this for 16 years, I believe, when I went and got Force Science certified and seen many, many cases. And it changed the way that I see the officers doing things. There's also memory loss and that they experience because it's a very stressful situation. They might think they heard something when they didn't. They might have heard something that they don't remember right away, and then they remember it months later. It comes back to them. It happens, and it's important to remember that it happens not only with officers, but it happens with the suspects, and it happens with the witnesses too. And the reasons for that is you know, you get those physiological changes in the body that in a stressful situation affects the brain's ability to perceive and to remember. And what we do know is that memory becomes best. It's not best right there for the person who is in the stressful situation. So it's really different for an officer to give a statement right away than it is for a witness, because the witness likely is not in the stressful situation. They are viewing it from an outside perspective. The officer is the target. And so the memory recovery begins after a night's sleep, and the best memory occurs after 2 sleep cycles. It's important to remember that they should have 2 sleep cycles, and sometimes that can be 3 days, because officers are not going to be able to sleep right after the fact. They're so worked up from being involved in an incident. So if they do give a statement, it's really important that their memory be given that time they need to recover. There's the alternative thought that, well, will it be reconstruction or contaminated based on what they hear and they see? That's a danger too. But I would much rather err on the side of allowing them and trying to keep them sequestered, that opportunity to recover, so that we give them the tools that they need to best defend their actions and explain why what they did was reasonable. So we've talked about some of the things that this can affect, and here they are listed, just some of the perception issues that can arise. Essentially, they can miss certain things or not convey some of the things that were occurring that can be inconsistent with the forensic evidence, and it's important that we understand that. Response time is also crucial. Response time, like the sound of light or the sound of speed, varies. I didn't know this, but a person's touch is the very quickest sense that we have. And I have this, and officers will be able to relate to this when they're dealing with a suspect. You know, sometimes they'll be handcuffing someone and everything seems fine, and they'll feel a person tense. They up and get ready to fight or flee. That is the quickest sense that they will have, and can happen in milliseconds. And I had a case that involved that, where we had a takedown caught on a video camera that looked like an officer just walks up to the guy and dumps him on the ground, but really, when the officer put his hand on the suspect's arm, could feel not only the person tense up, but then could feel him move his elbows back into the officer's body, such as to fight, and then move into a car that they were standing next to, which means a threat of a possible weapon, going through a possible weapon. And all that happened so within like 1.5 to 2 seconds. And it was explained to the jury. When the officer explained all of that, the jury understood it, and we were able to prevail on that claim. Sound takes a little bit longer, and sight is the longest. It also is affected by how complex things are, and how long a situation has been happening. So, you know, it affects not only officers but suspects. And what we need to remember is that officers can get shot and do nothing because of that delay in response time. That applies to suspects as well. And someone can be shot and continue to run and continue to fight against the officer. I had a neighbor ask me, why don't you just shoot him in the leg? Or why don't you just shoot the gun out of their hand? And they don't realize how, number one, difficult that is to hit a target that's moving from a distance. But they also don't understand that that person can still fight through things. They can fight through tasers. They can fight through gunshots. And this was interesting to learn from Force Science, that a person can be hit in the heart and still continue to function for up to 15 seconds. The only thing that will drop them immediately is a shot to the central nervous system, the brain stem, the spinal cord, and it's most often that does not occur. So it doesn't mean immediate incapacitation, excuse me. Time also depends on or how many shots were fired and whether to shoot or not also depends on our processing ability. And as we mentioned earlier, it takes a quarter of a second to see what is happening and to make a decision to take action. It takes another 10 seconds for an officer to fire a shot on the average. Some are a little quicker, some are a little less. And then it takes another 0.6 of a second. I think there's a misguided 0.0 in there to stop shooting. And so that answers the question often of why were there 12 shots fired? Officers are trained, as you know, to shoot until the threat is eliminated. And so when we have people who continue to function after they've been shot, the officer continues to fire. We don't just do double taps and assess anymore. Officers are trained to just continue shooting until the threat is gone. And then for them to see that a threat has ended takes more time, and a lot of shots can occur during that time period, and that's what can result in the number of shots being fired. And we just need to explain those to juries. When we do, they seem to understand that. And that's where that public trust, again, as we're talking about building that trust and that confidence in the public, is so important, so that when we get down to these situations, we are prepared and they are prepared to trust our explanations. So what all this means too is that suspects can get shot in the back and still have been a threat to the officer when they were fired. It can explain difference in trajectories. I had an officer who had a suspect come at him with a knife in very close quarters in a house, who maintained that the suspect always came at him and he fired 3 shots, yet he had the shots were in his left side, the suspect's left side, and then 2 in the rear side and then the back. And that explained exactly, we were able to explain exactly how that suspect was indeed coming at the officer with the knife when the officer fired, and then as the officer fired, that suspect is perceiving what's happening and turns in a defensive position, and the shots ended up entering his side and backside. We've gone through some of the problems with the statements. Inconsistencies are very dangerous to officers, and the reason for that is they are vested with a lot of power and authority, and they carry guns that can take lives. And so jurors give them a lot of leeway and a lot of trust, but when they feel like the officer is not being truthful, they're harder on officers than they might otherwise be on other people. And they really don't like to see inconsistencies. So there are always going to be inconsistencies. In fact, I get nervous if there aren't some inconsistencies in between witness statements. But we want the officers within their own testimonies to be as consistent as possible. And the fewer inconsistencies that we can have, the better off we are to defend the claims that result. So there's different types of inconsistencies that can occur. One is within the officer's own testimony, the other is with evidence, and the other is with witnesses. And the more inconsistencies there are, the more likely you're going to have a case filed, because people are going to think that there's a there when there may not be. And the more difficult it is to defend against those claims. So the more we can eliminate those inconsistencies, the better chance we have of preventing the claims and prevailing when there are claims. You also have the problems with the self-incrimination and the employment consequences for the officer, which include Brady-Giglio issues. Those are far-reaching for an officer. So the officer could be cleared criminally, but in the employment context, if they're found not being truthful, or if they're found not being truthful in a civil rights action, there are Brady-Giglio issues. And how do you put an officer on stand in another case when you have those? It becomes very difficult. So those are the problems that we face. The best advice I can give to the officers is never give one without a criminal attorney present. And that attorney can instruct the officer. This is not the employment context. The officer has a right to have that attorney present, and the officer can cut that off at any time and advise the person not to answer a question. Wait at least until 2 sleep cycles after the shooting. If the investigating agency won't allow that, the officer can say, okay, I'm going to give the statement, but I'm not going to do it until a certain point. That's, again, it is a voluntary statement, and that is whether or not. So the first question is, do you give it? And we talked earlier about the things that we assess. Now, those are the things that if we do give it, we want to make sure the officers do. It's critical that the officer go through the event with their attorney beforehand so that the attorney knows what to say. And it may be very advisable for civil counsel to be there as well, because a criminal attorney is not going to be keyed into some of the civil rights issues and can help. The civil rights attorney could help maybe direct a little bit, or help soften language sometimes that can be harmful, you know, and help prepare for some questions or issues that may come up that could have implications down the road in the civil case. The officer needs to make sure that the interviewer has experience in police shootings and that they have the cognitive interview training. I'm not going to go through the cognitive interviews. I think that is something that officers need to be specifically trained on. That doesn't mean going to a day-long seminar or reading a book. I've seen that happen. What I really want to convey to you today is how important it is for the person doing the interview to have that training. And it's in the officer's hands and the officer's attorney's hands to ensure that the person doing the interviewing does have that. The cautions I want to provide is that even fully truthful statements that include everything to the best of their recollections will produce inconsistent statements that aren't untruthful. It's just the nature of the things we've just gone over, all of the physical and mental and processing issues that we've discussed. It's really important for our interviewing officers not to apply training they've had, to review things in the eyes of the officers. And it's important to remember that I've had officers say, well, I didn't think the officer was the interviewing officers say that the officer being interviewed was being deceptive. But it's important because of certain things, and it's important to remember that some of those very signs of deception can be, you know, signs of them being deliberate, cautious, and nervous. So again, we're not looking at this from an advocacy standpoint, either from for or against the officer, just the facts. And it's important to remember that we can't expect those inconsistencies and delayed reactions. It's important for the interviewer to keep an open mind, using the information gathering approach, not confrontational. Officers who are being interviewed can also learn specific things. they need to understand that they have these weaknesses in perception and memory so that they don't commit to a certain place or a certain time, that they keep things broad so that it will not be inconsistent with the forensics. They need to learn to say it's okay to say, I don't know. It doesn't mean that they're being dishonest or trying to hide something. I don't know is a perfectly fine answer. There are going to be so many things happening so quickly, there's no way for them to perceive and remember every possible thing that happened. It's good to do supplemental reports, or if they remember something, if they've given an interview and they remember something after an interview that's important, they need to convey that to the interviewer later in some type of written or recorded form so that that is memorialized as well. And the sooner they do that, the better. It's important for them to prepare. It's not something that you just come into and wing. They need to and that's why it's so important to talk with the attorney beforehand and to go over the scenario and to then be very thoughtful about the answers. They don't need to rattle off answers quickly. It's not a sign of weakness to take a pause and to think about what the question is and to think about the response. It's actually preferred. We don't want them to rush. We want them to take the time. The very same things I tell them preparing for a deposition. And then it's really important for them to help the person interviewing them to understand what it felt like to be there. And that means including, you can't just have conclusions. I felt that I was in danger or that someone else is in danger. You've got to give the facts that backed it up. What was happening? You know, what did people sound like? What was the suspect's demeanor? What set the stage? I mean, were you in a church parking lot on a Sunday afternoon, or were you in a bar parking lot at 3 a.m.? And then it's really helpful, I have found, to have them explain it as it relates to their training. What that does is that gives validation and credibility to what it is they're seeing and doing, and then describe in what they did. Don't just tell them how you felt. Again, those are conclusions. Give them the facts that help them to feel what it was like to stand in their shoes. You got to set the scene, as we talked about. Oh yeah, I didn't mention lighting. You know, the history. If you know this person has a lengthy criminal history, a violent history, the history of the area, those kinds of things. What it was that the officer perceived. So here is, you know, the things that we remember. And this is where it's going to be very important for us now, for the officers, to take control over what they're conveying, because I fear that they're going to rely a little too much on their body cameras to just show everything. And as I explained in that one case that we had that was caught on the dash camera, recordings don't capture subtleties. They don't capture a suspect's tenseness in their arm. They don't, and there can be, just as there were obstructions in that witness who was in the building, there can be obstructions. You know, if an officer puts her arms out in front to fire, it can block a body camera. So they also don't capture the emotion of what it was like to be there. So that's important for the officers to convey those things. And if the interviewer forgets something, jump in and have them add that. Where are we on time now?
Sorry, I was muted there for a second. We've gone a little over time what we've planned here. Maybe
why don't we end here? I think, Jason, did you tell them that we have a second half to this session that we can do? And this is probably the best place to stop.
Okay, that would be great. We discussed this, and because this is such an in-depth subject, we discussed doing a second part of this webinar, so we can dive in a little deeper on some of the remaining material. But maybe if we could talk about a couple of questions that have come up to this point.
Absolutely.
A question on body cameras. Are body cameras basically a requirement now, even though there's no legal requirement? Is it an expectation that our departments would have those?
That's a great distinction, because as we've seen from last legislative session to this one, they're struggling, the legislature's struggling over what the requirements will be to have those body cameras. But yes, there is an expectation now that they will have body cameras. And I have been saying for the last 12 years, those body cameras are expensive, but they're a whole heck of a lot cheaper than I am.
Yeah, absolutely. And this is a comment from me, so take it for what it's worth. I've noticed, as I've worked with various departments out there, I've noticed different types of body cameras. Some are on the lapel or on the body, but I've noticed some that are placed right on sunglasses or an officer's glasses. And I thought, as we discussed this, what is the perception? What is the officer actually seeing? That could be a big distinction in the officer's experience versus it's on my body, if my head's turning somewhere else, that could be totally different. Anyway.
Jason, that is an incredible point, and one that I've actually talked with a lot of police agencies about. How do you decide what to do? And there are problems with anyone. But as we pointed out with Force Science, they can explain all of that. Mm-hmm. It's better to have it than not to have it. So I would encourage people who are looking at what type of body camera do we get? Do we get one on the lapel, on the front? Do we get one on the glasses? Talk to the people who have had experiences using them, find out what the pros and cons are, and go with what works best. And then those explanations can be different, or can be those differences can be explained.
Okay. Next question: drug and alcohol screening post incident like this. Some areas may have a policy. We do a drug and alcohol screen post an incident, any accident where there's property damage or injury to a person. What about that angle? Fourth Amendment issues, or what should an officer do? What should a department do as that pertains to is the officer under the influence?
That's a really great question. And again, normally we've just done that in the past. But again, that could be a problem for an officer. What if an officer had some type of measurable substance in the officer's blood? Or what if the officer had gone to Colorado 15 days ago and smoked some pot and came back and then had that measurable amount still in the officer's body? That providing of the fluid is a statement by the officer that can be used against the officer. That's why I counsel the officer to call their criminal attorney the very first thing. That cannot be compelled from a criminal standpoint. It can from an employment standpoint. So that's why it's so important to have these criminal lawyers up front first, because they can be the ones talking with the officer. Is this an issue? Have you been drinking, or is there going to be something on the screen? And if there is, then say no. They may say no. But if there isn't going to be any type of an issue at all, then yeah, go ahead and do that, and the officer can voluntarily provide that. Now again, that's different from the employment context, but we have to take a look. All of these things are tug and pull between the issues.
Mm-hmm. Question, what are your thoughts on citizen review boards? Should these be in place before an incident? Discuss the pros and cons of a citizen review board.
I think they're very important, because what they do is they give the public a level of confidence that law enforcement is not just policing law enforcement. The media has whipped up the concept that it's only the police policing the police, and the police don't turn on each other, which we all know is false. We are the first people to say if an officer is doing something wrong, we stand up for it. But I think what it does to have the Citizen Review Board in place before the incident occurs helps to have that level of trust. And then we have the board ready to go. They're trained, they know what to expect, and they're ready to do their job when this occurs.
Okay, great. I don't see any more questions coming in. I don't know if Doug and Brent have any that they've seen.
Negative.
Negative. Okay. Well, we've gone a little long here, folks. I appreciate your attendance here and hanging out as we've gone a little long. We will send out an invitation to the second part in this webinar shortly. We've still got to settle on a date and work that out, but this is an important enough subject that we definitely wanted to give it the time that it was due. So watch out for a notice on that. If you're not receiving our notices, please send me an email to Jason, Jason, @utahtrust.gov, and we'll get you on our distribution list so you get those notices. We recorded this session, and we'll be placing it on our website, so you can go back and review that as well. Final thoughts?
Jason, just my only final thought would be, if you would like to provide this PowerPoint to anyone, you're welcome to do that. I think it can be helpful because we talk a lot about things, but for them to have an outline, if that's helpful, I'm more than happy to say, please share that with them.
Great. Thank you very much, and we'll distribute that as we send out the notice that the recording is available, so you can refer back and forth between the two. Thank you so much, everyone. Thank you, Heather, for your time and all of the insight that you've given us here. This is an important topic, and I think we've all learned a lot from it. Thanks, everybody, for your service. We appreciate that, and hope you go out and have a safe day. All right. I'm having trouble shutting it down, but I'll get there eventually. Okay. For some reason, it won't do that. Anyway, figure this out. It's not giving me the right buttons. There we go. We'll make it work that way. Thanks, everybody.